participants. Bharati Vidyapeeth's Institute of Computer Applications and Management, BVI CAM, welcomes you all to the 4-day session 2 on simplifying IPR and patent filing of this 2-week refresher course or faculty development program in engineering, physical sciences, and management. I welcome amongst us our expert speaker for this session, Mr. Awab Habib Fakih. He is a multifaceted professional. With many awards and recognitions to his credit, he is an educator at the Al-Kalkiskar Technical Campus, a mentor startup at Ministry of Commerce and Industry, Government of India, an edupreneur, a patent analyst, and a researcher. With almost 19 patents filed till date, Mr. Awab is also the governing body member of Everest College of Engineering, Aurangabad, member and advisory board member, Board of Studies and IPR Cell, Maulana Azad University, Jodhpur, an experienced professional in the domain of patent grant and filing. We are privileged to have you amongst us, sir, today. I now request you to kindly initiate this session on IPR and patent filing.
Thank you so much for a generous introduction, ma'am. Thank you. I think my presentation.
Yes.
Yeah. Okay.
Yes, your presentation is visible.
Thank you so much. Thank you much. So I welcome Jyoti ma'am, Dr. Etheraz Raza Khan, Dr. Shwela, Lalit sir, Manzoor sir, Namrata ma'am, Pradhan sir, our own, our host, Ritika ma'am, Shalini ma'am, Shilpa ma'am, Sutpa ma'am, Vivek sir, a warm welcome to everyone. I'll make sure your complete 120 minutes is completely worth it. That's completely my responsibility as a speaker. So I will be dividing the complete session into two different parts. The first section, the first complete initially, like we can say 52 to 58 minutes, will be spending a valuable time on the different types of IPR. Like we have heard about 2 or 3 types of IPR, but we'll be having a look among all the 9 different types of IPR. In the second half, we'll be focusing on the complete one part of the IPR, that's a patent. So we'll be having a look about the number of process of application have to go through, the form which is required for it, where are the offices, the part online filing, offline filing, and so on. So here we go with it. So my dear colleague, when we talk about IPR, the concept of IPR was discussed back in 1845. Then again, the issuing of protecting IPR was first discussed in Paris Convention in 1883 and Berne Convention in 1883. Both the treaty are administered by WIPO. WIPO is an abbreviation of World Intellectual Property Organization. That means the concept is very old. So IPR is anything which originates from a mind, or we can say the creative work of human intellect or human brain, such as like songs which we listen on laptop, or we can say the floral design on bedsheet. The point is that now we call it as a property because like other property we have normally, like we have house, we have land, gold, etc. We can sell it, we can make money from it, we can trade, or we can also take a loan on it. Similarly, my dear friend, with IPR, we can sell our IPR, we can make money from our IPR, we can trade with our IPR, we can also take loan on our IPR. But the property here, what we are focusing over here, is the knowledge expressed in the document by the owner, or we can say the inventor. So all the team, what we have an amazing team over here. So let's consider everyone as an owner, everyone as an inventor for the coming 120 minutes completely. We have Deepa, we have everyone over here with us. Okay. So let's talk about more into it. We do not get any rights, my dear friends. Let's be very clear. Let's be very clear. We do not get any rights for idea and imagination. The information reflected in those information is a real subject matter of protection. For example, if I talk about, like, if I imagine about a flying car, that thing cannot be protected. That idea cannot be protected. But if I actually convert into a physical subject, then that is something I can protect. So like IPR is confined like to an invention to a particular territory. So in a simpler words, the laws are applicable only to that particular territory where they are granted. For example, if a IPR is granted in India, the IPR law, that particular thing, the invention, is only valid to an Indian territory. That's it. It is not valid to the European countries or so on. For that, you have to make a separate file to that particular country, and we'll be coming here in more detail about it when we talk about the patent. Further to it, like before getting into further details, I would like to explain you about the term for protection. The term for protection is the number of years for which the protection is given to the property holder, or we can say in our case, we can say the inventor. Like after completion, like after completion of the term, the invention falls into the public domain. So when we say about the public domain, that means like uh, anyone can use it without the consent of the owner, or or we can say with the inventor. So once it completes the term for protection, so when we start discussing about the patent, I'll tell you about the term for protection for a patent as well as the other IPR also. Every year, my dear friend, we do celebrate like World Intellectual Property Day, that is on 20th April. Let's IPR basically is categorized into two broad domains. One is like non-registered category, another one is academic category. Not all the forms of IPR requires registration. Like if we talk about trade secrets, like if you would say no, copyright it requires registration, right? But I'll give an example, like common example which I take it. If you see a institute website, or if you see some website, it is all is in almost all the cases it is written that the above content is copyrighted, right? You don't file a letter, you don't file a proper document to Indian government for it. So in this case, like IPR, right? You don't file a proper document for copyrighting that art content, but you still write it because that's your intellect, right? So that is something considered as a non-registered category. There are few people who are putting something into the brochure, who are putting something into the manual. They do copyright in a hard copy. They do a proper official copyright. That is something known as a registered category. And the second one is your trade secret. We don't do it. We'll see why. Why there is no necessity for doing that trade secret, because the name itself says you have to keep a secret, right? Let's go for the second one. The second one we are talking about the industrial slash academia. The industrial includes the patent, trademark, plant breeder's right, industrial design, geographical indication, traditional knowledge, trade secrets, and so on. And we talk about the academia. Academia only includes copyright. The copyright consists of literature, dramatic, any artistic work, but very important, that does not include any industrial process. It only includes any literature, dramatic, artistic work. That's it. So that's a broader bifurcation of all the different types of art into two different segments. One is your registered slash non-registered category, and the second one is your industrial slash academia category. Let's go for the next. So before going to further more detail, let's understand these four different terms. One is your act, rule, amendment, and term. So when you talk about, let's learn a little bit about the economics. Many of them might be knowing this term. When you talk about the act, a bill which has passed through various legislature steps required for it and which has become law. So these are categorized as a primary step. So when you talk about the rules, my dear friends, these are known as a secondary categories. They are in place to make the parent act work effectively. Rules provides details which have not been provided for in the act. But very important, however, rules by no means can go beyond the power conferred by the act or extend the same. And when we talk about the amendment is something like if any changes is brought in the rules or in act, so that is categorized any amendments. And next is your term. The term for protection for every IPR is your term for protection is granted for every type of IPR. So we'll be having a look in our coming slides. So as I said, there are 9 different types of IPR, my dear friends. So let's have a look. We won't be focusing more on the acts and rule part because I've already like made you aware what exactly an act is and what exactly a rule is. So we'll be focusing on two columns over here. One is the type of the IPR, and the second column will be focusing on the term for protection for each of the IPR. Okay. The first one is your patent. The term for protection for patent is for 20 years. So when I say 20 years, that means, for example, we have Dr. Manoj, Dr. Shwela, Dr. Yashna, Dr. Bhuvneshwar, Dr. Navneet. All of this team, if all of them form a team, if they apply for a patent, and by grace of God, with the effort, with the knowledge, everything what they have put down, they got a patent for it. So that means the patent which is granted to them is there for 20 years. That means, like me, Namrata, Narendra, we have Manzoor, we have Shalini, we have Shilpa, we cannot use it because they have been granted a patent for it. If we want to use it, we have to take the approval of it, we have to take the consent of the inventor, right? So that is the way it happens. So it will only become public after 20 years. So that's the meaning of term for protection. So an inventor, or you can say the owner, will get the rights for 20 years. That is very, very massive, very, very huge. Next is your trademark. When you talk about the trademark, my dear friends, initially when the trademark is granted, it is granted for 10 years, and we can keep renewing it after every 10 years for an indefinite period. That's the beauty of it. Indefinite period, but the condition is that after every 10 years, you have to keep renewing it. The third category is your industrial design. So industrial design, my dear friends, whenever a design is patented, so initially it is granted for 10 years. And if you want to, in case if you extend the same, you can do it by a proper application channel, and you can get it for more for 5 years. That means a 10 plus 5 format. Okay, so that's different type of IPR. Let's go for the other three, my dear friends. Next is your copyright. For the copyright, the term for protection is the life of the author plus 60 years after his death. So that's a huge, huge period for you get the time period for the copyright, my dear friends. The next category is your geographical indication. For geographical indication, the term for protection over here is 10 years, and again it can be renewed after every 10 years for an indefinite period. So my question to this amazing audience over here is, in the previous slide, we have seen one of the type of IPR which were having a similar term for protection as that of geographical indication. Which IPR was that? If anyone can answer into the chat room. In the previous slide, we have seen there was one of the type of IPR which was having the similar term for protection as geographical indication. You get for 10 years, and after every 10 years, you have to keep renewing it, right? So which IPR was that? If anyone can answer into the chat room, we have an amazing audience over here. Let's make it very interactive. Let's make sure that you have some takeaway after 20 minutes with it. Yes, we had a person who have taken initiative, that is Shilpa. Shilpa, yes, you are completely right. It was trademark. In the previous slide, we have seen a trademark. That is one of the type of IPR. In that case, the term for protection was 10 years, and you can keep renewing it after every 10 years. We have one more. We have Biswajit Nayak. Yes, completely right. Let's go for the sixth one. That's a trade secret. My dear friends, there is no act, no rules for trade secrets. That's the reason the term for protection is lifetime, because it is ultimately the job of the owner and the inventor who he wants to, because it is up to him how good he can keep his trade secret. Okay, so that's the reason there is no act, no rules. That's the reason we have said in the earlier slide there is no registration required for trade secret. So we have seen 6 different types of IPR, my dear friends. Let's go for the next one. Next three. Next is your plant breeder's right. The plant breeder's right, my dear friend, it is divided into 2 categories. One is the trees and vines, that is for 25 years. The other, any other plant, that is for 20 years. That's for plant breeder's right. Let's go for the next one. We already got answer from Lalit Kumar sir. Amazing, amazing. Yes, you're completely right. Let's go for the second last one. That's a traditional knowledge. Again, no act, no rules. The term for protection is for lifetime. So again, the question to this audience. In the previous slide, we have seen one of the type of IPR. Even that IPR didn't had any rules, any act. Even the term for protection was for lifetime. Which IPR was that? In the previous slide, we had seen one of the type of IPR. It was very, very similar to traditional knowledge. It didn't have any act, any rules. Even the term for protection was for lifetime. Amazing. We have Shilpa, we have Shalini. Amazing. Shilpa, you are extremely active. Thank you, Namrata. Thank you. I'm calling you by the first name. I don't know how senior you are to me. The last one is your semiconductor integrated circuit layout design. It's semiconductor integrated circuit layout design. We have Dr. Bhuvneshwar. Amazing, amazing, perfectly. So in this case, if the term for protection is for 10 years, and after that it will become public, that means if this was granted to Dr. Bhuvneshwar, and if I and Mr. Lalit Kumar sir wanted to use it, we can only use it without the permission of Dr. Bhuvneshwar sir after it completes its 10 years, so that it becomes public, so that anyone can use it. If me and Lalit Kumar sir, if we have to use it before that period, we have to take the consent of the inventor. So it works in that manner. So let's talk about the objective. Why to go for IPR? Let's go for it. So the idea, like the first is to give the recognition to the creator of the work. Like similar what we have discussed. Like if I and Lalit Kumar wanted to use it, a chip which was designed by Dr. Bhuvneshwar, but we cannot use it unless until we get permission from him, right? It could be in the royalty form, it could be in some other way. So that's the way. Like the Dr. Bhuvneshwar sir is getting the recognition for his creator, for his creation of the work. So that's an advantage of having an IPR, my dear friend. So, like every nation gives recognition to the creator so as to motivate him to perform better. He is rewarded in such a way so that he can enjoy the monopoly and the economic benefits by licensing, by selling his invention. Other objective is that to attract the foreign investment, and we see the TOT, that is transfer of technology. If new idea and innovation are created in nation, then it might attract the foreign investors. They may purchase the technique and the innovative technologies. Also, my dear friend, they may offer the use of their technology in the exchange of our technology. It is also important to maintain the harmony in the people of different kind of innovation in every field is rewarded with the protection, as the work of innovation in any field is equally time consuming and laborious. So if the right of the farmer, or you can say the artist, or you can say the inventors, like over the inventors, we could talk about Dr. Bhuvneshwari, we can have Lalit Kumar over here, we have Namrata, we have Shalini, we have Shilpa, amazing inventors we have over here. If their right is not protected, that is completely unfair, right? So there could be a chaos between the people from different field. So it is necessary to safeguard the interest of the owner of the work in every field. Recognition in different kind of like IPR is very important, because right to protect the right of the artist, farmers, technical people, traders, and so on. Like this is not only important, my dear friend, in maintaining the harmony, but also for recognizing the work of the intellect in different fields. IPR can also enhance the trade and investment in the country. And this is obvious by now. The development of technology and the innovative work would enhance the trade in a particular nation. Economic status will also improve. We can also take benefits from the international trade opportunities. The grant of any right, my friend, acts as an inspiration, or you can say as a catalyst, you can say for further invention, which ultimately contributes to the technological development of any particular nation. And as everyone needs recognition and rewards for the creation, that's the reason IPR has been formed. So let's go further with it. Let's have a discussion on each of the type of IPR. Will be focusing at least will be in, like we'll be spending at least 3 to 5 minutes on every type of the IPR. So let's go over it. The first one is your patent. Patent is a grant of some exclusive privilege right, or the authority, you can say, given by the government of the country to one or more individuals for a limited period of time in exchange of disclosing the invention. The inventor has a monopoly right for a particular period of time. So when I say a particular period of time, that means you already know what is the term for protection for patent. If can anyone can answer into the chat room, what is the term for protection for a patent? When I say it is given for a limited period of, so if anyone can answer into the chat room, what is the term for protection of a patent? Like if the patent is granted, for how many years the patent is granted? So we have got answer from Shalini, from Manzoor sir, Bhuvaneshwari, Lalit. Yes, amazing, amazing. The answer is 20 years. Amazing. Appreciate your efforts. Thank you so much for answering it. But when you talk about patent, it is for 20 years. We talk about semiconductor integrated circuit layout designs, it is for 10 years. I really appreciate your efforts. Thank you so much for answering it. You're motivating the speaker. Thank you. So when I say the limited period of time for a patent, if it is granted, it is for 20 years, my dear friend. Okay. So let's go in much more detail for it. So like if we according like for example in India, like a patent is granted for 20 years. So all these years, an inventor can rule over his invention and can use it in every possible way. So my dear friends, when I mean to say like by using in every possible way, I mean he can license his invention to anyone, can assign his invention to anyone. For example, like IBM licensed technology to many dealers and earn money from it. So basically, IBM earns royalty from it. So basically, like IBM is earning royalty from the other vendors. We can also take example of patent of Apple, new new technology. We can also talk about the new technology like the shake to charge, another like patented medicines combiflam. So that's a small brief about a patent. With this, let's have a small Q&A. Okay, we'll be having two questions for this amazing audience. Okay, so you have to answer it into the chat room itself. So you'll be getting 15 seconds for every question. Everything is timed up, so you have only 15 seconds. You can write question number one. What's your answer? What's your option you want to say? Question number two. What's your option? That's it. So here we go. Everything is timed up. Let's go for it. Question number one. Here is it. What protects the intellectual property created by the inventors? Copyright, GI, patent, registered design, trademark. Yes, we already got the answer from one of the participants, that is Shilpa. Second one. Thank you, Biswajit sir. Thank you, Lalit. Thank you, Namrata ma'am. Thank you, Shilpa. Thank you, Narinder. Yes. How long do patents usually last for? Amazing, amazing. So the correct answers are yes, Jyoti ma'am. I'll clear your doubt about the Australian patent as well. Yes, don't worry. Let's go for the next one. Amazing audience. Thank you so much for being so active. Dr. Sudha, thank you. Next one is your trademark. The trademark enables the consumer to identify the product by a certain symbols. This will help them to distinguish the product and service from one trader to the another trader. Trademark helps to get the goodwill into the market. As you all know, my dear friends, the famous McDonald's in which you always see a joker kept outside the store and the yellow color in which they write the McDonald's, right? So you can easily understand that this is McDonald's store and we can get a good quality food over here. So this is how the trademark protects the goodwill and the quality. It also helps, my dear friend, for the consumer in identifying the trademark. The trademark can directly appear on the product. For example, we have few of the example on the presentation itself, like slice bottle, the Coca-Cola bottle, no ringtone of Nokia MI, punchline of Lay's, Pal Banai Magical. So few of the examples over here. One of the example of trademark is Xerox. Xerox was registered as a trademark as electrophotographic copying machine and apparatus for fusing powdered images. Electrophotographic copying machine and apparatus for powdered images in 1952. It was used widely in this kind of copying technology. It thus reached a point in 1970 that the trademark almost became generic because many people like use, in fact, are using for photostat or photocopy. They started using a Xerox. So this is how a trademark becomes generic. So when you talk about the trademark class, there are 45 different classes in which you can register a trademark. The 45 different class is divided into two different segments. Class 1 to 35 is for the goods segment. If, for example, anyone over here, we have Dr. Bhubaneshwari, Shalini, Dr. Suhela. If anyone wants to register a product which is into goods category, they will prefer between class 1 to 35 depending on which type of goods it is. For example, if we have Shilpa, we have Narendra, we have Namrata, okay, and we have Lalit, if they want to register a company which is into a service segment, okay, so they would prefer a class between class 36 to class 45. If in case your institute logo is not trademark, my dear friends, you can trademark institute logo under education because you're giving a service, right? So under education category, you can trademark it class 41. So if it is not, you can take an initiative, my dear friends. So that's a short brief about the trademark, different classes, how you can register over it. Okay. So with this, let's have just a glimpse of different famous, one of the famous trademark, just for your references. We'll have only one question on trademark. If that question will be there for 15 seconds, that's it. And you have to answer in that particular chat room. Let's best of luck, my dear friends. Dr. Bhubaneshwari, Shalini, Bishwajit, Lalit, thank you, Dr. Suhela, Namrata, Narendra. Let's go for it. No, Jyoti, it is not sufficient. I'll clear this doubt as well. I'll be going for patent. Thank you, Jyoti, for putting up such an amazing question. Thank you, Jyoti. Yes, yes. Not during the session itself only. I'll include this question. Don't worry. So the correct answer is waiting for the answers. The correct answer is for 10 years. When you talk about the trademark, it is for 10 years, and after every 10 years, you can keep renewing it. Thank you, Dr. Bhubaneshwari. Thank you, thank you. So let's go for the industrial design. If anyone feels, if they have designed such an amazing equipment for some for XYZ purpose, if they feel they don't want to focus on the working of it, they only want to focus on the design part of it, my dear friends, here is the slide for you. Let's go for it. Let's talk about the design part. The design protects the distinctive appearance of product. These right is only concerned with the look of an article. That's how they function. Very important. Design. This design decision, my dear friends, when you talk about design patent, it is only considered, like it is the only important which is there in this when you talk about design patent. What is the important point? The look of an article is very important, not as how they function. You can take real life examples like a shape of a sports bike, you like, or you can talk about the floral design of bed sheet, handicraft, manufactured products, design of gold and diamond jewelries, etc. Now, if I talk about the industrial design, it could be a three-dimensional form, such as the ornamentation colors. It could be a three-dimensional, it could be a two-dimensional. Uh, it could be a combination of both, three-dimensional as well as a two-dimensional. So when I take a combination of both, for example, let's take an example of a car. So when you talk about the Volkswagen car, so Volkswagen car have an elegant shape as well as it has a unique color. So it can register under design category under both the category, three-dimensional as well as two-dimensional. Design, my dear friends, adds a commercial value for the product. Design, as you know, design makes the product good looking and attractive. So good looking finished product must be appealing for the customer, so that he prefers buying that over the boring design. My dear friends, we never buy a cell phone that has all features, but it is not good looking, right? So industrial design are important for adding for the look factor for the product. So it is very important to enhance the design of your product. So when you talk about the industrial design, when you talk about the term for protection, the term for protection is for 10 years. And further, if you want to extend it, you can do it by you can get for more 5 years. So it is 10 plus 5. But initially you get for 10 years. So that's a small brief about the industrial design, my dear friend. Or you can say the patent, the design patent. So let's go. Q&A or design patent. We have two questions over it. You'll be having 15 seconds each to answer it. So let's go for it. If any question during for the patent, anything you can put down into the chat room. I'll make sure I will include that in my presentation. The answer I'll include that in my presentation. So here we go for it. Let's go. So what is encompassed in the design as per intellectual property law? A, feature of the shape. B, configuration. C, patterns. D, all of this. Let's go for it. Dr. Bhubaneshwari, Jyoti, we have Shalini, we have Shilpa, we have Bishwajit. Let's go for it. We have an amazing family with us. Thank you, thank you, thank you, Shalini, Namrata, Manzoor, Vivek, Dr. Yashna, Dr. Suhaila, Lalit, Bishwajit. Let's go to the second one. The duration of design patent. The duration of design patent. Yes, Shalini. Thank you. Thank you, Manzoor. Yes, Vivek. Absolutely right. Amazing audience we are having it. Amazing. I don't know how you good you're enjoying it. I'm enjoying it with you guys. Amazing people we are having it. Let's go for the third one. We have copyright. Let's start discussing about it. So anyone who loves music over here, so I do love it. So let's start with that. For example, if I love music, yes, Vivek loves it, even me too. So like I listen to FM every day. I hear songs of Arijit Singh, Sonu Nigam, Rahul Ved, and so on. So all these singers have like copyright for the piece of work done by them. Then the broadcasting right are also given by these FM broadcasting organization. The copyright is concerned with the protect of original literature, artistic work. The copyright substance in original dramatic, musical is very, very important. When we talk about the Copyright Act, the Copyright Act came into effect in 19, like it was formed in 1957, my dear friend, but it came into effect from January 1958. It was 1957, but by the time it came into effect, it was January 1958. So we can take an example of copyright that is like the right of a performer. We can say a famous actor, Amitabh Bachchan Saab, has a right to control his performance given by him in any stage show. Then the right of broadcasting organization. So here we can talk about the FM channels like Red FM, FM Gold, and so on. They have the right for broadcasting and rebroadcasting of their program. The other examples can be A.R. Rahman song, M.F. Hussain paintings, and so on. Copyright is often called as a bundle of rights. This name is given since its main work is to protect the unauthorized use, but also add several other rights to the list of the owner. Author gets the right of production in various forms, such as the printed publication, or you can say the sound recording form, and so on. The public performance can be done, such as the novel can be converted into theater. You have seen movies in which, like, you have seen examples like movies in which the novel has been converted into a movie, right? Then the recording of the work can be made in the form of a compact disc, cassettes, videotapes. Broadcasting could be done by radio, FM channel, and so on. Then it's again like translation could be into another language, like Three Idiots, where it was translated into Chinese, and again like it made a lot more money in compared to India in China, right? So again, like we can talk about like conversion of novel into screenplay and so on. So all this right, my dear friends, all this right is when like it can be enjoyed by the owner, or you can say it can be enjoyed by the inventor. That is the reason the name bundle of right is justified for this kind of IPR. That is nothing but copyright. So that's a small brief about copyright, my dear friend. Let's have a small Q&A for copyright. Let's go for it. We'll be having two Q&A for this amazing audience over here. We have we have Rani, we have Vivek with us, Dr. Suhela. Let's go for it. Best of luck. Here is the question for you. We have two questions for it, 15 seconds each. A very, very, very tricky. Let's see. Is unpublished book can be registered under Copyright Act in India? Yes, no, yes in some cases. Shilpa, you are very fast. Lily, in fact, Lily Rani, ma'am, you are very, very fast. Yes, we have answer from a very dear host, Ratika. Ma'am, thank you so much for being so active. The Copyright Act, second question for you. It was formed in 1957, but it came into effect from. Yes, we have answer from Biswaji, we have from Bhubesh, Bhuvneshwari ma'am, Shilpa, Ritika ma'am, Dr. Amazing. I mean, Namrata, thank you, thank you, thank you. Amazing, amazing, amazing audience. The next one is the geographical indication, my dear friends. So next, when we talk about geographical indication, basically, before starting, I want two things from your end. A sincere request to this amazing audience over here. One thing, tell me any product or any handicraft product, any food item like which is very 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 famous from a native place wherever you stay. Okay, any product which is very very famous for native place, which is like which have a very very good reputation into market. It could be anything, it could be handicraft, it could be a food item, anything it could be, right? So if you can mention the product name and the place where it is famous for, anything. So it already Vivek have initiated, amazing Vivek. So let's start discussing about GI. So it'll become very very easy. So when I talk about GI, that is geographical indication, basically, my dear friends, it is a tag. Notice stating that the given product originates in a given geographical area or the product is manufactured in a given geographical area. Now that this tag is given to the product for three things, my dear friends. Number one, quality. Number two, the characteristics. Number three is for the reputation. These features can be found if the same product is manufactured or grown at some other place. This right is applicable for a manufactured or the original goods. These characteristics, my dear friends, or we can say the quality, may be due to the major factors like natural factors, method of manufacturing, and etc. It could be like now when you talk about the natural factors, it can be soil, it can be regional climate, it could be temperature, it could be moisture, it could be so on. For example, when you talk about like we have few of the examples here, Mr. Vivek, right? He said about the jute items in West Bengal, Kolkata. Uh, we have Dr. Bhubaneswar who said about turmeric. Yes, amazing. We have Manzoor Ahmad Saab who said about the apple in Kashmir. Yes, we like if we talk about Maharashtra, you can say if I want to talk about oranges, there is a place known as Nagpur. So Nagpur oranges are very famous in Maharashtra. For example, the method of manufacturing, it can include like specialization in the product or the preparation method. Like if you talk about Tirupati Laddu, the geographical location promotes the good or the producer for a particular area so that the consumer will be sure about the quality of the originated or the manufactured products. Like for example, if someone wants to purchase a bulk amount of apple, right, he will always prefer Kashmir, right? If someone wants to purchase bulk amount of jute items, he will prefer Kolkata, right? So that is the way geographical indication it works so well. So that tag is so important because it gives economic benefit. Because anyone who wants to purchase, like anyone from a European country, if you want to purchase some product from India, he will definitely look where that product is famous for, where that product is originated for, because he will have an assurity that yes, the quality from this place will be the best what I wanted, right? Because they are very very concerned about the quality. Because in India, when you talk about over quality, we prefer the pricing, right? But in European countries, the quality is the priority. So that's the way the just geographical tagging, it's really really important over there. For example, if when you talk about someone like if Vivek had given a good example like jute items from West Bengal, right, in Kolkata. So, for example, if a person who is producing a jute items in Maharashtra, okay, but he's selling a jute item saying that but he's selling to a third person by saying, no, this jute item has been manufactured from West Bengal and I'm a trader, right? So in that case, like he's misusing it, the brand of Kolkata, because they are very famous for it. Okay. So when if it happens in that case, there are two people who can take an action against it. One is the registered proprietor, and the second one is the authorized user. The registered proprietor and the authorized user are the two concerned people who can take action against these cases, right? So this is like very, very important. The government doesn't take it initially. These are the two people who will take the action against it, the registered proprietor and the authorized user. So just a small brief about geographical indication. I'll just show you a chart about the geographical tags. We have answer from Lily Rani about the Kinda Kaja. This is just sample the GI tags just for a reference. The state-wise, the number of tags and the examples what they have been tagged. So it really helps in the business. And when you talk about the business trading kind of concept, so GI tag really helps in that way. So if you think if at a native place, if your any colleagues, if your family members are doing business in your particular area, and that particular product is very very famous and it is not have been GI the GI tag has not been tagged yet. So please help them. It will really help them to improve the economic benefits there, because when you talk about the import, so it will really help them. In import and export, it will really help them. GI tag plays a very, very important role in import and export. So with this, we'll have a small Q&A for the geographical indication. There'll be 2 questions for you. Every question will be there for 15 seconds. That's it. So here we go. If anyone from this audience, anyone having any doubt for regarding the patent, you can keep putting your questions down. As Jyoti have already mentioned 2 questions for patent, so I can help you answering during the presentation itself. The question number 1: which of the following is are included in geographical indication of goods? A, handicraft; B, foodstuff; C, manufactured; D, all of the above. Yes, Namrata, you are very, very fast. Thank you, Namrata ma'am. Thank you, Ritika. Thank you, ma'am. Thank you, Manzoor Sahab. Thank you, Vivek. Thank you, Dr. Shwela. Thank you, Bhuvneshwari. Yes, Biswajit, Lili Rani ma'am, Dr. Navneet. Amazing. Question number 2: who can initiate an action for the infringement of a geographical indication? If someone misusing the brand, the GI tag, who can take an action against it? Namrata, again, you are very, very fast. Thank you, Namrata, for being so active. Dr. Raza Khan Saab, thank you. Yes. Is the registered proprietor and the authorized user, they can take the action against it, not the government initially. So with this, we'll be going for the trade secrets. Very, very simple, very, very interesting. I'll give one of the best example for trade secret, which everyone in fact knows about it. So basically, this is an information that you do not want the competitor to know about. The law generally protects not a secret formula and design, but even simple facts such as the feature that might be introduced in the next iPhone, or you can say which country a business intend to go into the next. And then we can talk about the into like famous trade secrets of KFC, McDonald's, Coca-Cola, Google, because the information that is used in the operation of a business. So once a trade secret is revealed, the value of the trade secret also goes away. So when I talk about the value, my dear friends, the value here is the economic advantage over the others. So your competitor will copy the secret recipe or the formula or the trick to make their business successful. So we can say the trade secret can be a business related, financial cooperation, customer list, and so on. It could be a technical related, it could be drawing, it could be model, it could be prototype, and so on. So in trade secrets, the confidential property is not a property since it is not registered. Because in trade secret, there is no act, no rules, right, my dear friends? So there is no registration at all. So there is like, if you say like the confidential property, there is nothing known as property over here. You can say because unless until it is not protected, you cannot call it as a property. You can call it as a trade secret for your business. That is what we have to take care of it. Okay, that's a small one of the famous example of the trade secret, which is almost close to 150 years, very, very close to 150 years, about the recipe of Coca-Cola. The secret had been kept in Walter Bank of Atlanta. So one of the famous example when you talk about the trade secrets. So let's go with this. Let's go for the Q&A for a trade secret. You'll be having only one question for it. You'll be having 15 seconds to answer it. Let's go for this amazing audience. By the time, if anyone having any doubt regarding patent, anyone having any query about the patent, you can put that into the chat room. Thank you, Lani. Thank you, Bhuvneshwari. Thank you, Raza Khan Saab, Namrata, Dr. Navneet, Biswajit. Thank you, Dr. Suhaila. Amazing. Let's go for it. Best of luck. That's a question. A little trickier one. Little trickier one. The thing to be very focused in this is what is not valid. What is not valid? That is the crux. A little trickier question. What is not valid? That's the point. That's the key point. You have to hold it. Let's see. What is the correct answer? The correct answer is confidential information is a property is not valid when you talk about in terms of trade secret. So the other points, my dear friends, B, C, and D, all were valid points. Okay. So let's go for the next one. That's a traditional knowledge. Very, very simple. I think without having like me saying anything, we can have a amazing discussion itself in the chat room. Any traditional knowledge which you have got from your grandparents or from your parents or from your aunts or from your family members, whenever you visit to your native place, anything, you can comment it into the chat room itself. So that will something will be like we are talking about traditional knowledge. Anything it could be a natural therapy which your parents or your grandparents or your auntie, your uncle, your cousins, whenever you might be visiting to your native place, they might have told you to use that, use this, it will be helpful for your health and so on. So that is something, everything is covered into traditional knowledge. If you can convey what your experience about traditional knowledge into the chat room, it will be really be helpful. It will really help others as well to understand. Okay, with this I'll just say a few words about traditional knowledge. If you can contribute with in the chat room, it will be really great. So let's start with this. The knowledge gained and which is then used by the people over generations. So these are the knowledge which is gained and used by the people over generation. These type of IPR is given to knowledge that is common in a particular community, like the knowledge of a turmeric or the use of turmeric for wounds. Then this knowledge is carried from one generation to another. Knowledge is difficult to preserve in a form of a proof. So we all know that India has a rich traditional knowledge that is passed verbally from one another. And for that, the Indian government have taken an initiative of developing the traditional knowledge digital library. Traditional knowledge digital library, that is TKDL. So whenever you get a time, you can have a visit to TKDL website, my dear friends. So this project was initiated in 2001. So the TKDL is a collaborative project of Council of Scientific and Industrial Research, that is CSIR, within collaboration with the Ministry of Science and Technology and the Ministry of Health and Family Welfare. Now, like if you're talking about a few example of traditional knowledge, it could be use of tulsi, the neem tree, the turmeric in India, and so on. We can talk about the Ayurvedic medicines, the use of aloe vera in removing the pimples, and this is all this everything, my dear friends. It's mentioned into the TKDL website. So whenever you get a time to visit the TKDL website, my dear friends, you'll observe the major categories in TKDL website are agriculture, fisheries, health, horticulture, and forestry. These are the major categories: agriculture, fisheries, health, horticulture, and forestry. So that's a small brief about TKDL website, my dear friends. Let's go, because that's a very generic topic. So let's go for the next one. That's a plant breeders' rights. That's the reason I have not kept any question for it. Let's go for the plant breeders' right. That's something like, as Indian breeders developed a large number of new varieties that are freely available to others for the exploitation. But the plant breeders' right, my dear friends, are also known as the Protection of Plant Varieties and Farmers' Right Act 2001. It is also known as the Protection of Plant Varieties and the Farmers' Right Act 2001. That like protects the interest of the breeders as well as the farmers. We have to have a very balance between both. These rights safeguard the interest of the farmers of India. It is an incentive for the farmers and the breeders for development of improved plant varieties of agriculture, horticulture, and forestry. So like it could really help in like in case of exporting it, importing it, then we can offer it for sale, selling it, or any sort of marketing we can do by stocking it in any of the above purposes, my dear friend. For example, like commercial strawberries, wine apple, and so on. So that's a small brief about plant breeders, right? Okay. We have a little trickier question for plant breeders, right? There are two questions, 15 seconds each. A little trickier one. Let's see. Let's go for it. So anyone having any question for it? Jyoti, Lily, Dr. Bhubaneswari, Dr. Razak Saab, Namrata, Dr. Navneet, Bishwajit, anyone? Here we go. Best of luck. That's the first question for you. A little trickier one. A little trickier one. Let's go for it. Question number two. This is something like anyone who was really active, they can answer it. And which in our case, everyone, my complete family was active. I have an amazing family together today for my webinar. Since the question was big, I have kept the time like almost 23 seconds, 24 seconds. Amazing. Thank you, thank you, thank you. So the correct answers are yes in some first case, Yes, thank you, Manzoor, Shalini, Dr. Anna, Dr. Navneet, Namrata. Thank you, Suhela. Thank you, our dearest host, Ritika ma'am. Thank you. With this, we'll be going with the last type of IPR. That's our semiconductor integrated circuit layout designs. Let's go for it. The creation of a circuit and its layout design has been given a separate category of protection under IPR. As smaller the size of an integrated circuit, less the material needed for its construction, and smaller the space needed to accommodate it. But obvious. So this condition requires lots of efforts by the technical people, and has the protection of these efforts has become important. It provides a protection for semiconductor integrated circuit and the layout of the circuit. So anyone working into circuit designs, so this is for you, my dear colleagues. It plays a significant role in the advancement of technology, especially for the electronics and the information technologies faculties, academician. Integrated circuit are used in all the data processing equipment like mobile phone, laptop, watches, radios, washing machine, and so on. Semiconductor integrated circuit are often called as microchip, or you can also say a chip. It can function as a timer, counter, microprocessor, etc. Like it can be digital or analog. Integrated circuit layout designs refers to the 3D characteristics of the element and the interconnection of integrated circuit. For example, like if you talk about the layout of a transistor or any of the circuit elements and so on. So that was a small brief about semiconductor integrated circuit layout design. So a last question for this last type of the IPR. Do you remember what was the term for protection for semiconductor integrated circuit? Anyone can answer it? What was the term for protection for semiconductor integrated circuit? When I said a term for protection, that means, for example, if this IPR is granted, if you had applied for it and it is granted by Government of India, how many years you can hold the ownership in semiconductor integrated circuit? Anyone can reply it. Can they reply? Anyone from this audience? We have Dr. Bhuvneshwari, Lalit, Mandur Sahab, Shalini, Dr. Anna, Dr. Navneet. We have Namrata, Shalini, Dr. Suhela, anyone? Shilpa? Anyone? Anyone can reply yes. When you talk about semiconductor integrated circuit, it is for 10 years. Amazing, amazing. Yes. But once it completes 10 years, it will become public so that anyone can use it. For example, if this IPR was to be granted, if it has been granted to Namrata, Shilpa, Dr. Anna, Dr. Bhuvneshwari, Manzoor, and Lili Rani, if it was granted to this people, right, this academician, so if Awab wanted to use this, then I have to take permission from all these inventors. Without the permission, I cannot use it in within that particular period. Once that this completes its complete 10 years of span, right? So anyone can use it because it will become public. So that is the difference of term for protection. So these are the types of IPR we have seen it today: patent, trademark, industrial design. We have seen copyright, geographical indication, trade secret. We have seen plan readers, traditional knowledge, and your semiconductor integrated circuit layout design. So we have invested almost our 58, 57 minutes on it. That's for the first half. Anyone having any doubt about it, my dear friends, I have made a special FAQ question for it. There are 121 common FAQ question which has been asked to me during all my webinars till date. Okay, so I've made a 121 question on all the 9 types of IPR. So all your doubts could be cleared. This link could be shared by our dearest host Ritika ma'am. So don't worry about it. It will be shared by her. So all your doubts will be cleared with this FAQ questions. Okay. So with this, our next agenda is about the patent, about the basic Indian patent filing. What are the process? Which forms have to be used? What are the forms we have to be used? What is the complete procedure from the application to the grant stage? How it is it exactly working into Government of India? Where are the patent office in India? What are the jurisdiction? Who are the people working into the patent office? What are the kind of if we get patent, right? So how it works? What do you mean by licensee? What do you mean by assignee, and so on? So everything will be having a look. How much time it requires for the patent process? For example, if you are giving it to someone professional, how many hours he should invest on a patent? How many hours he should invest on drafting? Okay, all this will be covering in next 50 minutes, 55 minutes. So we'll be having a short break to this amazing audience because you were very active. With the permission of Ritika ma'am, we'll have a break of 3 to 4 minutes, 5 minutes maximum. It's 4:54. We can exactly start at 5 o'clock without any delay for it. So we can end exactly at 5:55 or so. Okay. So that's a
Sure, sir.
so that's a 5 minutes break for everyone. If they can fresh up themselves. Thank you so much for being such an amazing family. Any questions if you're having it, you can shoot into the chat room. I'll make sure it is covered into the next part because next session will be completely focusing on patent. Any question regarding patent, please, you can post into the chat room. I'll make sure it is covered during the presentation. Thank you, Manzoor Saab. Anyone in the audience, if they have ever faced any difficulties while filing patent, even they can share the experience, or if they want to, if they have any doubt regarding to patent filing, if they're done with the procedure, please let me know. I'll help you out. Because even I have faced failure with this. So we have 2 minutes more. We'll be resuming with our presentation. Yes, Dr. Raza Saab. Yes, I know it. Dr. Raza Saab, I'll give you the reason for it also. Thank you so much for putting up this question.
Yeah, but then it moralizes someone who really wanted to do his own work. I find so many people around me doing this. 8 to 10 people.
Okay. Dr. Raza Saab, I have an amazing answer with my presentation for this. I always do cover this point. I'll give you the answer as well. I completely understand, respect your question. Thank you so much, Raza Saab.
Thank you so much.
Thank you so much for joining. Thank you, sir. You have been amazing. So it's 5 o'clock, as it was committed. So I think we should stay with our commitment. With permission of Ritika ma'am, if we could really continue.
Sure, sure. Sure, Awab sir.
Thank you so much, ma'am. So the best way to predict the future is to invent it. So let's have a journey of coming 15 minutes. So coming 15 minutes, let's understand a short process about the patent filing. Let's go for it. So let's start with the bang on with the golden slide. If some, because maximum of the people have this kind of query, how do we judge? For example, if people are working on it, how do we judge on our own? How like for example, how me and my mentor or how me and my colleague should decide is my product patentable or not? How we should judge before filing the question, right? So according to Indian Patent Law 1970, so these are the three clauses which we have to satisfy for it. Let's go one by one by taking few of the examples, my dear friend. So once I take the example, I think it will be much easier for everyone to understand. Okay, so let's go for it. Yes, Jyoti, you can put your questions for it. Yes, I'll definitely cover up. That's completely my responsibility. If I don't, I'll definitely cover up after this webinar also. I'll be available. That's completely my commitment to you. So let's go with this. The first one is novelty. So like the first thing is the application should be new. It is not like the product should be completely new. The point is the application should be new. So suppose I say that I have invented some new transparent watch and now it works like a computer. Now you can operate as a computer, but the watch concept is already known in the market for long, right? But the way we are applied, for example, if the we would be like we have an amazing team over here. We have Dr. Raza Saab, we have Jyoti, we have Manzoor Sahab, we have Lili Rani, we have Bhubaneswari. For example, if these are the five inventors with us, that could be we. If they have applied a concept of like a digital concept in that watch, and that application wasn't there before, the watch concept was there, but this digital concept wasn't there before, then in this case, like what they have done, they have added a small chip in the watch so that it can act as a computer, and it has got a functionality that is that it is transparent also. So I, in this case, like all these five inventors had to put lot of intellect so that it can look transparent, attractive, and like it can work as a computer. So like you'll be having a computer, small computer on your wrist. So this is something like you can say novelty. Only condition that it should not be available before. So it is like you don't need to completely discover a new thing, my friends. Like we said, by making a time machine or something, it is not that difficult at all. But make sure the application is new. And suppose, like you said, if you are making a completely new product, that is excellent. That is way beyond. But even if you cannot, but if you make sure the application is new, you satisfy this criteria, my dear friend. Let's go for the next one. That is the inventive step. So now if I talk about the inventive step, you have to bring, for example, like you have to bring some economic or a technical factor, which is very important. Things which is already done in the market cannot be repatented, as everyone knows about it. For example, you cannot repatent a wheel. So if I talk about a drug for a cancer, which is already there into the market, okay, so that, for example, that drug is made by Dr. Raza Khan and Jyoti and Ritika ma'am. Okay, so this all these people have already made a drug for a cancer which is already there into the market for 8,000 rupees. Okay, so this is team A. Okay, so we'll be having a question later on once we understand. So let's understand the situation. So there's a drug into the marketplace which is made by Raza Khan Saab and Jyoti ma'am and Ritika ma'am. So these are team A category. Okay. Then by looking at them, team B could be Manzoor sir. It could be Dr. Bhuvaneshwari, Dr. Anna, Shilpa, Namrata, Lalit Kumar, and Shalini. So team B is this. Okay. All of you are team B. They feel ki no, even B can make it, and even they start working on it. And after a duration of 12 to 18 months of hard work, all the intellect they have invested for it, and they could come up they were very successful in making a drug, okay, which was like as effective as the drug which was made by team A, okay, but with a different chemical composition. So team B successfully made a drug with a different chemical composition, and now it is like the what work that drug A, which is doing, which is made by team A, the similar work is done by the work of team B, but the point is with a different chemical composition. So my question is to the audience over here, the amazing audience which we are having over here: can we patent the product which is made by team B? Yes or no? What is your answer to it? I hope you have understood the situation. So the question to you is, can we patent the product which is made by team B? Yes or no? Amazing, amazing. Thank you so much for being, because this is the way we'll understand the concept, my dear friend. Thank you so much for being such an amazing family. Thank you. Thank you, Dr. Manoj, Dr. Navneet, Dr. Shilpa. Yes. Okay. I'll say you're partially right and partially wrong. Okay. How it is you're partially right and how you would be partially wrong, I'll explain you the situation. Okay. Let's go into much more detail. Thank you so much for being such an responsive audience. So let's go into much more detail. So team B was successful. They made a drug with a different chemical composition with the same price. But the point is that, my dear friend, the team B did not show any efficiency or any enhancement in the result, or any economic factor is also not changed. Even team A was selling for 8,000 rupees, even team B selling for 8,000 rupees. And it is just treating the cancer the way the team A drug is treating the cancer. My question is, why it should get patent? Why people even will use a drug which is made by team B? Because already there is a drug which is made by team A. It is like you have put your intellect to use a different chemical composition. That does not mean you will get patent. My dear friend, this is how the patent examiner will analyze your application. Okay. Now let's see how you're partially right, how you would be partially right. And now let's understand. Okay. So so for example, then in that case, then team B starts working on it. Okay. And if they start improvising on it, okay, they think, you know, there should be a technical, economical, and technical factor also should be improved than team A. Okay. If they provide some experiment that resulted into less money, not 8,000 rupees, let's consider 4,000 rupees, particularly has got less side effects than the team A drug. Like it will only kill the cancer cells, it won't harm the healthy cells. Okay. So by showing it this improvisation as compared to team A, then only, my dear friend, they are eligible for the patent grant. Neither they are not, because this is how the all the parameters will be judged by the examiner. So this is how also, my dear friend, you have to judge it. It is not like using if you have used your intellect, right? You have used your intellect, but the point is that there was no improvisation in the economic factor. Also in the like the efficiency was also not increased. So this plays a very important role, my dear friend. Okay, make sure with that. The third category, the third one is a capable of industrial application. Okay, so let's start discussing about it. So let's start with the golden statement, my dear friend. It must be useful for the humankind. Simple as that. It shouldn't be such an application that does not give any benefit to humankind. It should have some industrial process involved, like alkalization, or you can say any chemical process or anything. Suppose, like, see, if I bring an invention and I say that you can hypnotize a person, that is like, no, that is not an invention, right? This is not made from industrial process. It is just a thing to harm a human being. or it won't help in any other way, right? For example, if then people start working on it, let's start like, okay, hypnotize wala concept, let's start using it some other way. Like in that case, like Dr. Yashna, Dr. Manoj, Dr. Navneet, Dr. Shilpa, Jyoti, and they start working on it. If they start working on it and they start improvising it, if they feel key, let's make it in a different way. So they said key, like suppose like if we have used this hypnotize using a clock that move to and fro, it will help a person who is suffering from schizophrenia. And suppose like it will help him to cure his disease, then you can get this registered. So this is how you have to tackle your product or your apparatus or your concept with proof. This is how you have to show that it should be useful to humankind. That is very, very important. So these are the three basic criteria, my dear friend. Whenever like you are discussing, you are working on some product, make sure you satisfy the criteria. Okay, so that's the basic rule when you talk about the patent. Okay, so let's start discussing more into it. Let's go more into it, my dear friend. Let's talk about the basic definition about the licensing. What do you mean by licensing? What do you mean by patenting? Let's start talking about this part. So we'll start a definition. I have seen your question, Jyoti. I'll make sure Kate is included. Thank you for it. So let's start definition related to the right of a patent. Like patentee has got many rights. Like he can license his invention, he can commercialize it, he can assign it to someone. So the owner is basically called as a patentee. A patent can be applied by many people. It can be through a first inventor, as it is said by Raza Khan Sahab. Like there are people, one is doing the work, there are 9 other people who are joining him and who are filing the name. So that is also ethically not correct. So why they are doing it? So let's go into much more detail about it. So when you talk about the Indian patent over here in this case, so what in this case, if anyone wants to file an Indian patent, if he does not have that kind of knowledge for it, he has a good knowledge about the product, what he's working on it, but he doesn't have a good knowledge about the patent law system and so on. In that case, he'll be either hiring a patent attorney or a patent agent, okay, who can prosecute the application and proceed with the application on the owner's behalf, or we can say on the inventor's behalf. So now what else he can do? He can assign when I talk about he means that means the patentee. The patentee he can assign his invention to someone. When like someone is going to assign the invention, he will completely transfer all the rights of invention like licensing, commercializing, manufacturing, exporting, importing into that assignee. So that person will be called as assignee to whom all the rights are assigned. And that assignee will pay a lump sum amount to the patent owner, that the patentee. So now all the rights are given to the assignee, and now the license is like if you're going to license it to someone, then you are just giving the title into the third party. For example, there are two different cases. For example, there is a patent which is owned by Jyoti, Dr. Yashna Sharma, Dr. Navneet, and Vivek. Okay, they are owning a patent. And me, Raza and Ritika, ma'am, Dr. Raza Khan and Dr. Ritika, we all three we want their patent. Okay, so what we'll do, we'll approach them. If we approach them, they have two choices. Either they will sell the complete patent, okay, so we have to pay a lump sum amount, and then we'll get the complete patent, and then we'll become the assignee. We all three, me, Dr. Raza, and Ritika ma'am, and we can use the patent for the complete 20 years, and we can use up to our own choice. We will have the license for the licensing, commercializing, manufacturing, exporting, importing, everything we can do it. What if the party who is owning the patent, he feels ki no, we cannot give you as a assignee. What we'll do, we'll give you the title of invention, okay, on a rental basis, or we can give you the license. We can give you the license for this uses for a 3 years period. So after 3 years, you have to get back to us. You cannot do anything with after 3 years. So it is completely up to the owner how you want to deal with this patent. So that is the two ways. Either he can give it completely to the third party, either he can give it as a licensee for a particular period of time, and he can use it, and after that he has to return back to the owner. Okay, depending on the terms and condition. Next, Then further, like you can license the invention in two different modes. One is the exclusive mode, one is the non-exclusive mode. Let's understand by taking some examples. Okay. For example, we as a whole, I'll give you an example. For example, there is two teams, Team A and Team B. Team A is our complete family who are with us in the chat room. We have Jyoti, we have Dr. Yashna Sharma, Dr. Manoj, from everyone, from Manzoor and Shuela, everyone with us. Okay. And Team B is Awab and Dr. Ritika. Okay. Team B is Dr. Awab and Dr. Ritika, and team is everyone from this chat room. Okay. So let's understand. And the patent is owned by Team A. Patent is owned by Team A, and Team B wants the patent. Patent is owned by Team A, by all the audience in the chat room, and Team B wants the patent. So team A can license their patent in two different modes. Okay. For example, team A can license the patent in the exclusive mode. What do you mean by exclusive license? Exclusive license means, for example, if this particular license is given to team B, if it is given to Awab and Dr. Ritika, okay, their company can only manufacture, their company can only license, and so on. Everything will be done by the company. There will be no intervention at all. And if team A feels key, look, let's give the exclusive license to them and let's earn a good profit margin from it. And what happens in team A, Dr. Manoj and Dr. Navneet feels, no, let's not go for the exclusive license. If we go for the exclusive license, that means we can only give it to only one manufacturer, that is Awab and Dr. Ritika, only to their company. Because if we are giving to only one company, there will be always be a limitation for the production, right? They can make 10,000 products in a day, 20,000, 50,000, but there will always be a limitation because there are humans being involved, right? If you're giving it to only one company. What Dr. Manoj and Dr. Yashna feels key, no, we should go for a non-exclusive license. If you want to earn a good amount, let's go for non-exclusive. Let's give for 10 different licenses in 10 different states. That is the meaning of non-exclusive license. So now there would be question to this amazing audience over here. Then why people they will go for non-exclusive? Sorry, exclusive. People will always go for non-exclusive because they will earn more profit margin. I'll give you a reason, my dear friend, when they will go for exclusive. Let's take a situation this. You have given 10 different manufacturer in 10 different states. What in case your layout is something which is very, very important in your product manufacturing, it's been leaked. If it is leaked, it is very, very difficult. Practically, it is next to impossible to tap it down. It has been leaked from which manufacturer, from which state. Very difficult. But in other case, my dear friend, when you give an exclusive license to Dr. Ritika and me, then if anything goes wrong, you are very clear. Awab and Dr. Ritika should be held responsible for it. They have to be answerable. Because you're very clear, everything, the responsibility is given to them. They have to deal with it. Because if something goes wrong, even Awab and Dr. Ritika will lose their economic front, right, compared to other people. If anything goes wrong, even they'll be very cautious. So there are two different modes, exclusive and non-exclusive mode. I'll give you an example. Like when IIT Delhi had made that COVID testing kit, and they had made a condition that this kit should not be sold for more than 500 rupees. So they had called various other manufacturers. So they hadn't gone for exclusive mode. They had gone for non-exclusive mode. Why? Because the COVID testing kit, if they go for exclusive mode, there will be a limitation in production, right? But if they go in non-exclusive mode, they can produce n number of kit and it could be helpful for many other people. So it varies from case to case, business to business. So these are the two basic examples how we can go for it. For once you get the patent, how to go about it, exclusive or non-exclusive. That's completely up to your choice and situation. Next is about the people who are involved in the patent office, my dear friend. So when you talk about the patent office, my dear friend, let's start discussing about this. There are several authorities in the patent office. The patent office, my dear friend, is basically a place where you go and file your application. The office is completely responsible for handling your application, receiving your application, giving you stamps, telling you what objection have been raised, what application is allowed or not, if you can file the application or not, if your application is correct or not. they are responsible for all the matters responsible to the application. So if my dear friends, if you really want to file an application, you can go to the patent office. Patent office is situated at 4 parts of India: Delhi, Kolkata, Mumbai, Chennai. Now, when you talk about the head office, it is in Mumbai. This four office is divided according to the jurisdiction. I'll in later slide I'll tell you the jurisdiction also among all the. Like for example, the people from north can file in Delhi. The people from east can file in Kolkata. The people from west can file in Mumbai. The people from south can file in Chennai. So this is the complete structure, my dear friend, about the patent office. So now, like you can talk about the authority of the patent office. One authority is the examiner that is responsible for examining the application. He will check all the prior arts. So you might be questioning here, wow, what is prior arts? So let's have a look. Prior arts basically is a state of art, or you can say the work that has already been published in the particular field. So the document containing that work will be a prior art. So the examiner will check all those prior art. He will check the procedure formalities are completed or not. Further, any objection should be raised or not in the application. He will look after all those things. He will complete his duty, transfer the application to the controller. Controller is something like how we have the head of the college, right? We have the director or principal in our institute, right? The same thing is like the controller is into patent office. So the controller will perform the final check on the application, whether the application is objectionable or not, or it should go to the straight away to the grant stage, or amendments are required. Amendments are like some changes, like if some spelling is wrong, or like some object or some subject matter is inappropriate, or your intention is describing the subject wrongfully. Anything it can be, my dear friend. So controller has many powers. For you should know that the controller is the highest authority who can either grant the patent or completely refuse the patent. Controller can give opportunity of hearing to any one of the applicant at any stage of the prosecution. As of now, we have discussed three important things. One is the controller, the examiner, and the patent office. Now let's like talk about the patent agent. Many fields, my dear friend, like many of the academician fields, the patent agent are like the government employees. Let's be very clear. They are not the government authorities, but they are private workers who represent the application of the people in front of the controller. We can hire a patent agent or we can file it separately. There is nothing, a clause mentioned by the Indian Patent Act that you have to hire a patent agent or patent attorney. It's only like since they will make the work much more organized and much more easier because they have a better knowledge than us. That's it. Because we are good in making invention, they are good in making the drafting and process. That's the only way we work in a collaborative manner. If someone feels that they have a desired knowledge for it and they have that kind of skill set to file a patent, they can go it independently. There is no compulsion that you have to hire a patent attorney or a patent agent, my dear friend. Since they are completely aware of the law, so they'll make it much easier. So when you talk about the register is maintained, my dear friend, in the patent agent office, where the patent agent number, all details, identification are maintained. Like anyone who feels ki if they want to make a career into patent agent as a patent agent or something, so every like after every 2.5 years or 2 years, there is a patent agent examination conducted by Indian Patent Office. So you can attempt that examination to become an official Indian patent agent. In fact, this year the exam was on 27th June, but it has been delayed because of COVID. So this register like is different. Like when we talk about the register which is maintained for the Indian patent registers, so all the numbers, details, everything is maintained by the Indian Patent Office. So this register is different from that of the patent register because in this register all the matters related to patent are written. So like for example, if you are going to assign to someone, okay, so that thing will also be written into the patent register. If you are going to license it to someone, even that thing will be written into the patent register. So if you're filing an invention outside India, even those things will be written into the patent register. So anything which will be affecting your patent application or your grant application, anything with that, everything is maintained by the Indian Patent Office. So those matters have to be written into the register. And the register is basically like how we maintain our register. It is maintained by the controller. So this is how the functioning goes into the patent office, and this register are maintained just like we maintain our register. So one more thing we have written into the slide is your opposition board. Let's understand this. Opposition board is a board constituted in the patent office itself in a case where opposition comes. For example, me, Shilpa, and Jyoti have an application, okay, and we all three have applied for a patent, and the patent is granted. If the patent is granted, it's kept open for 12 months so that anyone, if they have any query, if they have to oppose it, they can oppose it. So in that case, if Dr. Manoj, Dr. Navneet, and Dr. Raza, if feels no, it should not be granted, it is conflicting with our patent, then they can oppose it. In that case, the opposition board is formed. So in India, my dear friend, there are two opposition. One is pre-grant opposition, one is post-grant opposition. One is pre-grant opposition, like once you file an application, once the patent is published on the Indian patent website, you can still oppose it, even before the grant of the patent. One is post grant. Once it is granted, it is kept open for 12 months. If you have any query with that, you can appeal for it. You can put the post grant opposition. So in India, we follow both. We have pre grant opposition, we have post grant opposition. We have both the opposition available in India. Okay. So that's the way it works. That's a small thing about the Indian Patent Office and a few other important terms. Next is all about the priority. Let's understand this part. Very interesting. Very. I'll make it very interesting by taking some examples. Okay. For example, we have two teams. Okay. Amazing. We are getting few questions for it in the chat room. Thank you, Jyoti and Shilpa. Let's make it interesting. We have two teams over here. Okay. Team A is all the audience over here. We have Shilpa, we have Jyoti, amazing audience over here. Dr. Manoj, Dr. Yashna, Vivek, Manzoor, Namrata, Dr. Suhela, Shalini, amazing. Dr. Raza Khan Saab, Manzoor, Dr. Bhuvneshwari, Dr. Anna. So let's go, Namrata. Let's go for it. So you are completely team A, and team B is me and Dr. Ritika. Okay. So you all are working on a particular product for almost like 2.5 years. Okay. So your work is almost like you have come down to a conclusion, like 94.5% of the work is completed. Okay. On the other hand, me and Dr. Ritika are working on the same, because we don't know each other, but obvious, and technology is advancing so fast, there have to be like it has to have like they might be like two groups who are working on the same product, even they don't know each other, right? It will happen. But we have only completed our work like almost 60%. Like we started hardly a year or so, or 12 months or 15 months. We have completed only 60% of the work. But what is the advantage with team B, me and Dr. Ritika? Dr. Ritika is very well aware about the process of patent application. So she tells me, Awab, let's file an application. The first question is to me. First question which I have to throw to Dr. Ritika. Dr. Ritika, are you sure we have only completed 60% of the work? Can we apply? Then the answer towards it is Dr. Ritika said, yes, Awab, we can. I said, how? We have not even completed the product. It will still take us almost 12 months of time. Then Dr. Ritika will tell me, Awab, there is a provision in Indian Patent Act known as provisional application. What happens in provisional application? You only have to put down an abstract and drawing. You don't have to put the claims. When I say claims, claims, my dear academician, claims is something where you put down your points for which you are asking this invention. Okay, this is yours, the unique points. On what basis you are asking a patent for this product. So the claims are not mandatory when you talk about provisional application. Dr. Ritika said, let's go with the provisional application, okay, and let's go with the abstract and drawing, and then we have 12 months of time. Indian government will give you 12 months of time. Within that 12 months, you have to complete your application. And what happens, like after 2 months of the time, team A submits the application. Okay, team A will submit the application with the 100% of the work. Now my question is to the audience, which application will get priority? Team A or team B? Which application will get the priority? Team A have completed the complete work, 100% of the work, and they have not submitted provisional application. They have given complete application, but they have given after 2 months. We are team B. We have given it earlier than team A, 2 months prior to it, but we have only given a provisional which is incomplete. We have to still complete it. Who will get it? Dr. Raza Saab, Shilpa, are you sure about it? So that is the meaning. Like Dr. Raza Saab, Shilpa, and Biswajit, Namrata, Shalini, Dr. Navni, Dr. Bhuvneshwar, thank you so much for being such an amazing audience. Yes, the answer is Team B. That is the point. That is was the concept we'll be studying over here. The point is the priority date. Because when you either you go with provisional application, either we go with the complete application. The point is that, my dear friend, if you feel you can complete your work within 12 months of time, you can directly go ahead with the provisional application, because the day you file the application, you get a date, right? That date is known as a priority date. You should not prolong your date, as like you should file a date as early as possible, because the you have already got the priority. Even the team A have completed the work, still team B have got the priority, because in India we follow first to file system. In India we follow first to file system, not first to invent. So that is important. It is not important because who is. So now you will tell me, Awab, this is completely unfair. This is not good. But my dear colleagues, just think, how do you expect the person sitting in patent office to judge who started first and who haven't started first, right? So they only follow with the application date. That is the reason in India we follow first to file system. So this is very, very important. That is the meaning of priority date, my dear friend. Okay. So with this, you have already understood there are two way of system. One is the provision application, one is the complete application. For complete application, the claims are mandatory. For provision application, abstract and drawing are sufficient. Without claims, even you can apply for it. Okay. But make sure from the date of the application, within 12 months, you have to submit the claims. That is important. Okay. So now one of the question we were having about the global patent. Okay. So my dear friend, let's be very clear. There is nothing known as a global patent. Nothing known as a global patent. Yes, Dr. Raza sir, everything is there. Everything is there. Yes, everything is there in coming slide. I'll clear everything, sir. That's completely my responsibility. Okay. Next is like someone feels ki no, Awab, we want a global patent. Tell us how to get a global patent. I'll tell respected academician, there is nothing known as a global patent. With one application, you cannot get patent in all the countries. Nothing like that. So he'll tell me, Awab, is that means for every country, is for example, if I want to apply to 100 countries, so do we have to apply for individually for every countries? I'll say yes. That is. He'll say that is not possible. How to get a priority date? For example, if I apply in 10 different countries, so ultimately someone else will start making a product and he'll apply for it. He'll get a priority date in next 11 country. Is it not possible? So I will say, yeah, okay. There is a solution towards it. There is known as a convention group of countries, known as a PCT application. That is Patent Cooperation Treaty. What is a PCT application? I'll tell you, my dear friend. Okay. For example, Dr. Jyoti want to have a international patent in 11 different countries. Okay. What she will do, she will not apply to that particular country, because if she start applying for a particular country, every country will take independent time, right? Okay. So what she will do, for example, Dr. Ritika over here is having extremely good knowledge about the patent filing. Okay. So she will guide me and Jyoti and Awab, make sure go with PCT application. So we'll question her, Jyoti, Dr. Ritika, why? So Dr. Ritika will reply to us, listen, when we go with PCT application, what is the beauty of it? In PCT application, you have a collaboration of 152 countries. So we'll tell, okay, then what about 150 countries? What is the advantage? Dr. Ritika will tell us, if we file application with PCT application, with that PCT application, you get a priority date immediately in all those 152 countries. You get a priority date in all those 152 countries. That is the advantage. And then you have a breathing period of 30 or 31 months. In some countries 30 months, in some countries 31 months. Breathing period of 31 months to proceed with the application. And now me and Dr. Jyoti will decide which country I should prefer. We already got a priority date in 152 countries. Now we will decide which country should we go for, because that means we are already safe. No one from those countries can apply for it on that particular invention. So that is an advantage of PCT application. In other case, if we hadn't met Dr. Ritika, if we had started applying individually to different countries, then it would take a hell lot of time, right? So that is like something like a a negative point. Like we would have lose our invention, we would have lose our idea with someone else in some other country. So that is an advantage having PCT application. Now your question would be, Awab, do PCT application granted? No, no, no. PCT doesn't have the authority to grant a patent. PCT is only a channel who is giving you access to 152 countries immediately. It will only help you to give a priority date, number one. Number two, it will give you a search report that will make you confident it is unique or not. So that's an advantage. So if you want to go for an international application, this is important. For example, in another case, okay, for example, in another case, let's consider Namrata. Okay, Namrata and Shalini. I think, are you there? Namrata and Shalini, if you can say yes. If they are there, Namrata and Shalini. For example, if Namrata and Shalini are there with us, okay, if Namrata and Shalini feels ki Awab, we don't want to file an Indian patent, okay, we directly want to go for an international patent, can we do it? I'll say ki Namrata and Shalini, yes, we can do it, but there is a condition. You have to fill a form 25. With form 25, you have to take an approval, then you have to go for an international application. Neither what happens, my dear friend, the rule is that if you have to file an international application, you have to file that patent in India. Then once it completes 6 weeks of the priority date, from the filing date, if it completes 6 weeks, after that you can immediately start filing in international countries. So that is the norm. And if you feel no, you in any case you don't want to file in India, use form 25, get the approval, then you can file an international application without even filing in India. That is also possible. Okay. So these are the few situation, my dear friends, with respect to priority date, with respect to the international patent, how it really works. Okay. Few other person would be telling, for example, we have Dr. Akash. Oh, Dr. Akash, are you there with us? If you can reply yes, sir. We have Dr. Akash. We have Dr. Navneet with us, right? For example, if Dr. Akash and Dr. Navneet, if they are working on a product, okay, so they would say, Awab, we want to file this application, we want to file this patent. Do I have to make a working prototype? We have done the simulation part, we have done everything, the working, we have got the results, everything is done. Is it compulsory to make the complete prototype ready? The answer to this is no. It is not mentioned in the Indian Patent Act that you have to make the working prototype ready. It is not compulsory, my dear friend. It is not compulsory at all. Okay, so that this we have to make it very, very clear. It is not compulsory to have a working prototype ready. It is completely up to our choice for it. For example, if during the examination, if the examiner feels if they want to see it, so they by a time you can make it, because that the period is very huge. It's like you will be getting a year or two. So the period is very huge till the examination. So you'll have a good period of time. But it is not necessary to make the running prototype ready for filing the application. So few of the common questions for it. This is a jurisdiction office, my dear friend. For example, people from Mumbai, they can file the people from following states, the union territories can file in Mumbai. The people from following states and union territories can file in Chennai. People from following states can file in New Delhi, and rest of the India can file in Kolkata. Just for your information. Few of the important point, like if you feel yes, okay, my product is ready, everything is ready, tell us what are the how to frame the document. If you want to file a document for it, few of the most important point while filling a document is, let's go with it. Maximum points, everyone knows about it. Few of the important point is like something here and there that is like we don't follow it in any other document. Here we go for it. First thing, we have to use a A4 sheet. Number one, the size should be 29.7 centimeter by 21 centimeter, right? The length and breadth you have already understood. The top and bottom should be a 4 centimeter. The bottom and right should be a 3 centimeter. Okay. Make sure you start numbering every page. Your numbering should be on the bottom center in Arabic numerals. The numbering should be on every page, and it should be on the bottom center in Arabic numerals. Next important point, the printed language, it could be either be Hindi or English. Okay, both are official file language. Okay. Next thing, you need to put stress on the character size. The character size should be of 0.28 centimeter high. It should be dark ink. The line spacing should be 1.5. Either the document will look completely mess. It is also mentioned in the Indian Patent Act, my dear friend, the paper should be strong, flexible, white, smooth, non-shiny. Strong, flexible, white, smooth, non-shiny. All these things, my dear friend, it is written in, under Rule 9 of Indian Patent Act. One more thing, like we have already mentioned about the numbering of every sheet. Last very important thing, which normally we don't follow in any other document, we have to number the lines of a particular sheet. For example, in one sheet you have 25 lines. Example, okay. So you have to mention, we have to number the every multiple of 5. For example, the fifth line number 1, 10th line number 2, 15th line number 3, 20th line number 4, 25th line number 5. And similar, if you go to next page, again you start with number 1. So every multiple of fifth line we have to number it. Now your question would be, where to number it, Awab? Left hand side or right hand side? The answer is on the left hand side you have to number it. And if you go to the next page, again you start with the same. So this is something you don't follow in any other document, but this is what you have to follow into the, when you draft the patent application, you have to follow this norms. Rest everything is very, very simpler, which everyone follows it. Basic of Indian patent filing, my dear friends. Anyone like if he feels key, which are the forms to be used into Indian Patent Act? These are the following forms which are required: Form 1, Form 2, Form 3, Form 5, Form 26. Form 1 is the application for the grant of patent. Form 2, either it could be a provisional or a complete specification. Form 3, statement and undertaking. Form 5, declaration as to inventorship. Form 26, it is not compulsory. Form 1, Form 2, Form 3, and Form 5 are compulsory. Okay, I'll tell you, Jyoti. Okay. Form 26. Form 26, it is only used, for example, if you think no, you cannot do the complete process, you think you would require a help, you need a patent attorney, you need a patent agent for it. Only in that case, if you're using a third party who will prosecute your application, only in that case you'll be using Form 26. Okay. So next is your Form 18. For example, once your application is published, okay, so your publication takes almost 18 months of time. In that case, if you want to make your publication faster, for example, over here Jyoti had put, I think our question would be, why have you not included Form 9? Or I don't know if she wanted to ask or she wanted to convey. So the question is, like, if you want to make your publication faster, so if you want to make a publication faster within 30 days to 3 months of time, in that case, Jyoti ma'am, you can use Form 9. Form 9 is again is not compulsory, Jyoti ma'am. It is like completely optional. If you want to make your publication faster, to make like a publication something like once it is published, it comes on your Indian patent website. All the details are there in the Indian patent website. Your drawings, your claims, everything is there. Why? So if someone feels if they want to oppose it, a pre-grant opposition, so they see a document and they can oppose it before the grant. Okay. So Form 9 is completely optional. Form 26 is completely optional, but Form 18 is not optional. Form 18 is used when you have to request for the examination. You can request for the examination only after publication, my dear friend. And again, if you want to expedite your process for the examination, you can use Form 18A. Again, Form 18A is not compulsory. It is only when if you want to accelerate the examination process. That's the basic forms which are have to be used. Okay. Raza Saab was asking about this thing, the fee structure, everything. For you, sir, over here, we have three different categories. One is a natural category, small entity category, other than small entity category. So we have two options, e-filing and the physical filing. Okay. Small entity and other than small entity is basically for the companies, for the startups, for different. So this is what not has been required as of now. Okay. So let's, as an academician, as a researcher, we'll be using the national, we fall under the national category. We have two options. Either we can go for the e-filing system, either we can go for the physical filing. Physical filing, we have already seen there are 4 different offices in India. According to the jurisdiction, we can go for the filing. In government is giving flexibility for e-filing. For e-filing, they have kept a discount of 10%. The fees are lesser as compared to the physical filing. So government is like emphasizing on e-filing, so people can anywhere, they don't have to visit to the patent office. They can file anywhere across the India. They can file it online. So the e-filing fee is approximately 1,600 rupees. And someone feels ki, no, I want to go for only for design patent. I don't want to go on the working of the patent and so on. For design patent, the application fee is only 1,000 rupees. So these are the official government filing fees. Now, like someone will tell me, okay, tell us the complete about the other forms also. This is only the filing fees. What are the other charges throughout? Okay, I'll tell you that. I'll do that as well. So this is the complete structure. The first column is the form number. Okay, that's not the sequence. That is form 1, form 2, form 3, form 5, form 9, form 18. Form 1, 2, 3, and 5 are compulsory, are mandatory. Okay. Form 9, as it was put up question by Jyoti ma'am. Form 9, it is completely optional only if you feel if you want to make your publication faster between 1 to 3 months of time, only then you can use it. It is not compulsory at all. If you don't use it, still it will get published, but it will take almost 18 months of time. Form 18, yes, it is mandatory. After publication, we have to request for the examination. Okay, if you want to accelerate the process of examination, you can use Form 18A. That's the complete structure. The first column is for national category. Second column, the fees is for the small entity other than small entity. That means like a company having a turnover less than 10 CR, it comes in the small entity. More than 10 CR, it comes other than small entity category. Okay. For us, as an academician, as a researcher, we'll be focusing only on the small entity category. Let's go for the next one. I think, Dr. Razak Saab, I think your question was clear with this presentation, with this slide. If you
Yes,
are there
sir.
with us,
It's clear.
thank you so
Yes,
much,
sir.
sir.
It is clear. Thank you. Thank you so
Sir,
much.
we'll be having more in detail about it also. This will be next 3 minutes, my dear friends, my colleagues, my everyone who were there with us. I'll give you a complete flow chart how your application is processed under Indian government. Whoever have not gone for the patent till yet, you will understand the complete process with the publication till the grant stage. So let's go with that. I'll need your 3.5 minutes to explain this complete process. Stage number 1. Okay, let's consider the complete family. Whoever is there with us over here for this presentation, let's consider we all are filing for this application. The first step is for the application for the patent. For application for a patent, my dear friends, you have to fill form 1, form 2, form 3, and form 5. 1, 2, 3, and 5 you have to fill for the application. So once you put down the application, my dear friends, it goes for the publication. The publication will take 18 months of time. In case you feel you want the publication faster, then in that case you can use Form 9. Form 9, it is not compulsory, it is completely optional. Even if you don't use Form 9, it will get published approximately from the date of the filing, 18 months it will take. Once it is published, you can request for the examination. Here, this is what many people having a doubt for it. Many people feel key, okay, for the request for the examination, if I'm saying you'll be having 48 months of time, they feel it is the time is from the publication date. No, my dear friends. 48 months is from the application date, the prior date. Okay. From the date when you have filed it, from that within 48 months, you have to request for the examination. Okay. By using Form 18. And if you want to expedite your process with the examination, you can use Form 18A. Okay. So once you file an examination process and you have to prepare for the examination and so on, then you have to face the examination, give the response to the committee, to the controller, to the examiner, and the controller and examiner will come to conclusions. Let's say there are two conclusions. Okay. One would be yes. Okay. One would be no. So let's understand the complete process. What if it is yes, how it is processed? What if it is no, then how it is processed? Okay. If it is yes, that means the patent is granted. Congratulations to everyone over here in this and with our family. If the patent is granted, that means it is kept open for 12 months so that anyone can oppose it. Okay. Everyone in this chat room except Dr. Ritika is in team A. Team B is me and Dr. Ritika. Okay. So, for example, team A, I've already got a patent granted, okay, and now it is kept open for it. Dr. Ritika and I feel ki no, it should not be granted. It is opposing our patent. Then we'll put an application to the patent office. We'll issue a post grant application. Okay, we want to oppose it. Then a committee would be formed. Then committee would be hearing to both the parties. It will be hearing for the team A as well as team B. Team B is me and Dr. Ritika. Team A is everyone in a family over here in this webinar. Okay. So after hearing to both the parties, let's see what would be the three different conclusions. Number one, the controller and his team will say no. Dr. Ritika and Awab, what you are claiming, it is not making sense. What we have granted is completely fine. So the team A, the grant should be continued. So congratulations to everyone. Let's see what would be the second option. Second option would be to amend the patent. That means The controller and the team would say to me, or would say to team B, it would say to us, Dr. Ritika and Awab, few of the claims, it would say to the team A, because we had opposed it, okay, to team A. The controller would say to the team A, to our family over here in the webinar, they would say, listen, few of the claims which have been put up by Dr. Ritika and Awab, it is making sense. You have to make so many changes, okay, so changes, and then we'll continue with your grant. We are not rejecting it, only these changes are required, then you can continue with the grant. Third option we'll see it later on. Now, well, let's have a look. What if the answer is no? If the answer is no, that means the patent is refused. Still, you don't have to worry, because it works like how we deal with the cases, right? We file a case into civil court, and then if we lose a case, we'll go to high court, and then we go to Supreme Court. Similarly, it works over here. So you don't have to worry. Even if your patent is refused, you can appeal to the appellate board. Appellate board will year to year hearing. If the appellate board will feel no, the points put up by the team is completely fine. The decision taken by the controller and his team, it is not right, and they will grant the patent. They will allow the patent, and the patent will be granted, and it will continue the same process. What if the appellate board will feel no, the decision taken by the controller is completely fine, it should not be proceed further, and again it is rejected, and the third option would be again it will be rejected. So at any point, my dear friends, if it is rejected, you can always appeal to the appellate board, and you can appeal for it, you can fight your case for it. Okay, so you don't have to lose hope. Dr. Razak Sahab, with the new norm, with this amendment which has been made in 2019, they have expedited the process, especially for the startups. And recently, like if you have one woman as an inventor, even the process can be expedited. So maximum you can get within 16 to 18 months of time with the complete expedite process. That is possible for, especially for startups. It is possible. Earlier, yes, the time duration was between 3 to 4 years. You're completely right. But recently, especially for startups, and especially for if you're having one of the inventor as a woman, you have a good flexibility to expedite your process. You can get it between 16 to 18 months of time also, the Indian patent. So if someone will see here, Awab, tell us, give us a short summary, like tell us the complete summary in one slide. So this is a complete summary in one slide. The complete from the date till the publication. If, for example, if Dr. Raza Saab will say, ki, Awab, tell me, highlight the segments where an applicant have to work on it. Highlight the segment, which step an applicant have to use it. So here it goes. So the highlighted one, this is the process which an applicant have to do it. The inventor have to use it. Okay. So these are the highlighted one where the inventor, the applicant, the owner have to work on it. Okay. So, and this highlighted one, this process is executed by the government office, the IPR. Just for the clarity, which process should be done by the applicant, which process is done by the government. Just for the clarity. So everything done, the major part is completely done. This is the further knowledge. I'll be moving very fast because the PPT will be shared with you. I'll be moving very fast. Just give you a glimpse about it. 3 ways: selling the product, license, and selling a patent. 3 ways you can earn it. Market survey to understand the expectation of the consumer. Your consumer may have different views of the product, yes, and they may have different expectations. This is all is valid. This point, all 4 points are only valid when you are working for a startup. You are thinking of making this product live into the market. Only in that case it will really make a difference. Understanding the study of technology and landscape. So this is all something like only for your knowledge. So even you can read it. There's nothing to explain much in it. Since you'll have my presentation from Dr. Ratika, so don't worry about it. There's nothing like to explain much in it. It's only for your references. Identification, all these points are only applicable only if you are thinking to launch a product, or you're working with a startup, or you're working with a company. Only in that case it will make a difference, not as an academician. Make sure if you're working with R&D team, make sure never a salesperson should never comment to a R&D team. I'll tell you a reason why. Because a salesperson will only give a recommendation to what he sees into the market. An R&D team makes a product what is not there into the market. They should only view his recommendation only about the user availability, like what user really wants, okay, not what he sees into the market, because he'll only give the opinion what he sees into the market. So make sure your R&D team and the market team should be separate. That is really important. You should take in feedback, respect to the audience feedback to various product. So right, even when the R&D team will be making a product, so they will have a glimpse about it, how the consumer have behaved with this product, how the consumer have behaved with that particular product. So with respect to that, they will be making their own product. IP audit, like it is only applicable only when you are working with startups and the IP is playing major role, because for example when your IP is stopping other players to use that product into the market, only in that case the IP audit is very important. Patent draft, my dear friend, this is the only part, this is the heart of the patent application. That is the reason you hire a patent professional, because you have invented it, you are very good in drafting it, but the way it should be drafted for the examiner point of view, that is the reason you need to hire a patent attorney or patent agent. That is the heart of your patent application. So drafting is, this skill set is utmost important while filing an application. This is the way, if someone like Dr. Raza Khan had put up why people are doing that, and I'll tell you a reason for it, Raza Saab. And someone, if they wanted to know okay, what are the number of hours a patent attorney or patent agent or you should invest to it, I'll give you a complete glimpse about it. So let's divide into 4 different stages: patentability search, patent draft filing, answering examination, and the grant maintenance. This is the 4 different stages, right? Your patent application will follow. Stage 1. Stage 1, my dear friend, these are the different tasks. Either you or your patent agent or your patent attorney should follow it. Your patentability search is utmost important. That means your prior art search. Okay, I'll give an example for it. Okay, let's consider a situation. It's 5:56. Okay, I have 4 minutes. Let's consider a situation. For example, me and Dr. Ritika, okay, have published a paper. Okay, have published a paper and paper is made public. Okay, can we file a patent? Yes or no? What's the answer? Question is to the audience, amazing audience. We got an answer from Shilpa. So me and Dr. Ritika, we work on a product and we want to file a patent also, but we have published a paper. And we only want to file a patent. Shilpa, think about it. Vivek, think about it. Don't be in hurry. Me and Dr. Ritika want to file a patent, but we have published a paper. Even the paper is on our name. Even the patent application will be only on name, right? Both of us. That's it. No one else. No third party. The paper is published on a name. So paper is published, and then we want to file an application, patent application. Tell me, can we file a patent application? Yes or no? So we got an answer from Shilpa, Vivek. We got an answer from we got an answer from Nishita. We got an answer from Vishwajit, Namrata. Because this is the scenario, my dear friends. This will really help you to understand the procedure. Okay, amazing. We got an answer from Dr. Fakanda, Anna, Dr. Nami, Dr. Bhuvaneshwari. Yes, amazing. Manzoor, amazing. Let's go for it. The answer is no. The answer is no. Why? I'll tell you the reason why, my dear friends. My dear friends, in India, if my idea, my work is made public, that means when I do for a prior art, the prior art, it includes the patentability search. It also includes a non-patentability database also. When I say the non-patentable database, that means it will also search IEEE, Science, and everyone, Scopus Index, everything they will search. And if they are searching everything, that means if I want to file an application for the patent, my paper will be a prior art to me. That means it will show, it is already done. It is already public. Now you cannot do for a patent. So this gives you a study. That means if you want to file a patent, you should not make public. In US, it is not the other way around. In US, like Even if for example, me and Dr. Ritika have published a paper, made it public, within 12 months, if we file an application for a patent, it is possible in US. But still, it is very, very risky. But US, it is possible with the norm, but India, it is not. Once you make it public, it is very difficult. Okay, so make sure if you want to file a patent, don't make it public. Okay, so thank you so much for an amazing idea, amazing. No, not possible. Like if you put down the concept, everything, because they're really matching it, right? There are various checklists where you'll be having a priority search for. The next stage is your patent drafting. So these are the number of tasks, my dear friend, the number of hours you have to invest on patent drafting. So whenever anyone, if you're hiring it, your patent agent, patent attorney, or you are doing it by yourself, if you're doing it, make sure you multiply into 3 times, because you're doing it for yourself, right? For the first time. So multiply by 3 times. So you should invest at least 150 hours of time. Then only you'll make it very, very effective. If not, if you're hiring someone, make sure he should invest at least 50 hours of time on this format. It will really be successful. Stage 3, you're answering the examination. That is like once you apply the form 18 and so on. This is how it works. And when you add up all the three, it comes to 109 hours. I'll tell the answer now. Dr. Raza, my brother, had asked me. Dr. Raza said ki no, that there are people like who are contributing to it, where only one person is doing the work and contributing to it. But what happens, Dr. Raza? Uh, the government, and not every academician get a government support. Let's be very practical, right? Everyone is not so lucky to work in a government institute, right? Many people are working into a private institute, and private institute, very few private institute will fund you the complete process. Sorry, I've already crossed 6 o'clock. I need more 2 minutes. Sorry for it. Like,
Sure, no issues.
so like if we talk about an expert, like for example, an expert patent agent, okay, or a expert patent attorney or a patent analyst, right? If he's spending his 109 hours, just imagine a professional will charge 1,000 rupees per hour, a minimum, a worst scenario, right? So that's the reason the charges for patent goes up to 1 lakh rupees. I've bifurcated the number of hours which is required, right? People don't understand why they are charging it 1 lakh rupees, or why they're charging it 80,000 rupees, or why 90,000 rupees. So this is the reason. If they don't spend this much of amount, they will charge you less. That is the reason the market, there are players who are charging it. There are very, very good players in the market who will charge, in fact, more also, right? So that is the reason the charges are divided according to this number of hours, just for information. So for a one person spending a lakh rupee for a patent, it becomes very difficult. That's the reason what he feels ki let's gather people, so at least those people can contribute to at least to the financial segment. At least he will get his patent at least on his name as being the first inventor. Rest the other people can contribute. Other people can contribute in the financial way or another way. But ethically it is wrong. If people are putting their name, at least they should contribute in some other way. Technically also. That is really important. So if anyone wants to have a prior art, these are the following links, my dear friend. If you want to have a Indian database, global database, US database, and patent Google covers almost 104 countries. Okay, so all this link would be shared by Dr. Ritika also. So don't worry about it. So this is the prior data where you can have a look whenever you are planning to make file a patent. So make sure you can have a look at yourself, because you will have a decent idea what has been done and what has not been done. Said to be an inventor or innovator, feel young, look at a problem you face, my dear friends. Do not accept the problem, live with it. Start thinking to solve using engineering skills. Find the solution with the problem you face. Refine the solution. Make the prototype and refine it. Talk to friends. Don't think your concept, everything will be borrowed by someone else. No, your vision cannot be borrowed by anyone else. Ask these 3 questions to yourself. Can this be made? Can we make it? Can we sell this? If you feel you are very confident, my dear friends, go for patenting. That's the official Indian patent website. A complete set of 100 FAQ questions only on patent. This is not made by me, it is made by the government of India. Even this link is shared to Dr. Ritika ma'am. It will be shared to all your audience. All your doubts will be cleared, because I've already crossed my time. I'll just share my contact details for it. you can just connect me. I'll help you out in any way possible. So thank you, Professor Huda Sahab, Dr. Ritika ma'am. Thank you so much, the webinar team of Bharati Vidyapeeth, and most importantly, the reason our audience. Because, and last thing I want to say for Professor Huda Sahab, like one thing, because he loves शायरी so much, like कहते ना मंजिल से जरा कह दो अभी पहुंचा नहीं हूं मैं, मंजिल से जरा कह दो अभी पहुंचा नहीं हूं मैं, मुश्किलें जरूर है मगर ठहरा नहीं हूं मैं, because in such a difficult situation, he's been conducting such an amazing, he and his team is conducting such an amazing FDPs. Hats off to you, sir, and the team. Thank you so much for the invitation.
Thank you so much, Awab sir. It was actually a very inspiring session. You have involved the complete participants, all the audience, and you have made it a point to answer all their queries. Participant sir has already shared his WhatsApp and email ID and even his number. So I think any queries you have while filing of your patent or any problems you face while the same, you can easily communicate with sir. I know we have exceeded the time a bit. The session was so fruitful that it actually makes sense. Thank you so much, Awab sir, for your time. And please accept this certificate from our side just as a token of remembrance of this wonderful session that we have had today. So thank you so much, sir.
Thank you, ma'am. Thank you so much for the invitation, ma'am. Thank you.
I also thank all my participants who have participated in this session equally well along with sir, and they have cleared their doubts. Sir's PPT has already been shared with you as a study material. So in that case, any issues you have regarding patent filing, trust me, you can get in touch with Awab sir, and he is very quick to respond to any of your queries. So feel free to get in touch with him whenever the need be. Thank you so much, Awab sir. It was a wonderful session that we had today. All the participants are also appreciating it. We can see in the chat window. So with this, we draw curtains to this day, all the sessions of this 15-day refresher course in engineering, physical sciences and management. I thank all my participants and my expert speaker once again for gracing this wonderful occasion. And I hope our participants have extracted maximum knowledge out of this session. We shall be closing the session now, and we shall be opening the room again tomorrow at 1:15 for the next session. So thank you all the participants. A big thank you to you once again, Awab sir. And we hope to continue this association with you because it's a very knowledgeable association that we have. So thank you so much, sir, once again.
Thank you, ma'am. Thank you so much, ma'am.